Good morning, everyone. Welcome to Navigating Guardianships and Conservatorships. I'm Courtney Tarver, and I'm a volunteer with AARP Alabama. I'll be your host for this conversation about guardianships and conservatorships. I'm joined today by Judge Allison Boyd, probate judge of Shelby County, Alabama. Judge Boyd is a graduate of Samford University and received her law degree from the University of Alabama School of Law, as well as a master's in business administration from UAB. She practiced in Tuscaloosa as an associate with Sproul and Powell, Inc. in the areas of insurance defense, probate, divorce, and real estate law prior to joining the Shelby County District Attorney's Office in 2007, where she was responsible for prosecution of crimes against children, violent felony crimes, and served as a prosecutor for both the mental health court and the drug court programs. In 2016, she was appointed to serve as mental health program coordinator and legal counsel to Shelby County Judge of Probate, James Furmeister. After he was elected in June 18, Judge Boyd was appointed as Judge of Probate in September to fill the early vacancy due to the retirement of Judge Furmeister. She began her full term as Shelby County Probate Judge in January of 2019. Judge Boyd, like several of our other speakers we've had during this series, as well as the last one that we'll have next week, was appointed by the Alabama Supreme Court to serve as a member of the Commission on Adult Guardianships and Conservatorships. And she's also appointed as a member of the Standing Committee on the Rules of Conduct and Canons of Judicial Ethics. She serves as a member of the Alabama Law Institute's Adoption Committee, Board of Directors of NAMI Alabama, Vice President of the Board of Directors of Central Alabama Wellness, and Vice President of the Board of Directors of Leadership Shelby County. She's a member of Asbury United Methodist Church and serves as president of the Parent Advisory Committee for Red Mountain Theater. She's married and has 2 children. Good morning, Judge Boyd.
Good morning.
Each Tuesday in November, AARP has been proud to partner with the Alabama Commission on Adult Guardianships and Conservatorships, which was formerly a task force known as WINGS that studied these subjects. We are, during this series, breaking the topics or subtopics down in these areas so that hopefully they'll be easier to understand and discuss. Please ask questions, and as was noted earlier, the best way is to put your questions in the chat. But you may also, if you want to ask your question live, raise your hand in the Zoom program so that we can see that you have a question, and we'll come back to you and get those answered. Today, we're going to talk about 2 topics: the court process for appointing guardianships and conservatorships, or guardians and conservators, and then modifying guardianships and conservatorships. Judge Boyd will explain those areas and then take your questions. So again, put it in the chat or raise your hand. With that, we'll begin. Judge Boyd.
All right, very good. Thank you, Mr. Tarver, for the introduction, and also AARP for the opportunity to be here and for putting this together, because I think this is a great resource. I want to start by saying how excited I am to have these videos as a resource to our community. In Shelby County, with our probate court, we have valued these so much that we're actually in the process of making our website and redesigning our website to make these videos to where they're linked so that people can access them easily and share them within the community as they're looking for information, and I should say good information on guardianships and conservatorship that the need arises. So I will get started with the introduction. I will just say that in a time where you can't turn on the television, scroll through your social media feed, or even find a show to binge watch, as we've all been doing recently, without hearing about the topic of guardianships and conservatorships. It's an area that's often filled with fear and misconception. It's an area that's extremely important for those of us who are practitioners and those who routinely handle these matters to be well informed about the process and the procedure and be willing to share truthful information about the process of obtaining and the expectations for serving as a guardian or conservator. The most important thing that I think you need to understand as you watch the first video is that filing for guardianship and conservatorship should be a last resort. It should not be your estate planning plan to assist someone if or when they become incapacitated. The majority of guardianships and conservatorships we see through the court could have been avoided had a proper estate plan been put into place. While it's much rarer, we do have cases where a power of attorney or other estate planning document was not broad enough to allow the attorney, in fact, to take all the actions necessary to assist or protect the incapacitated person. But I will say that is very rare. Typically what we see is when there just wasn't a plan in place. And so this is the only thing and the only mechanism to help protect that person. I'll stress that although no one wants to come to court, especially not in this type of situation, you will see in the video that the process for obtaining a guardianship and conservatorship is fairly straightforward. So with that, let's go ahead and start video number 7, the court process to appoint a guardian or conservator.
If you've been going through this series, you know we've talked about everything except how to actually get a guardianship or a conservatorship. The reasons are twofold. First, guardianship and conservatorship are drastic interferences with a person's decision-making rights. And second, for that reason, every alternative should be explored before seeking a guardianship or conservatorship over someone. A court must find a person to be incapacitated before appointing a guardian or conservator. That means the person must have a mental illness, condition, or deficiency, a physical illness or disability, or be chronically addicted to drugs or alcohol. And that condition must prevent them from communicating their decisions or causes them to make irresponsible, harmful decisions about themselves or their property. Guardianship and conservatorship should not be easy things to get. At the same time, there may be good reasons why someone else may need to be appointed to take care of, make decisions for, and protect someone who is incapacitated. Here's how it works. It starts with filing a petition with a probate court in the county where the incapacitated person lives. You will need a lawyer to help you with this. Let's say your mom passed away 5 years ago. Your dad's physical health is declining and he has advancing dementia. He lives in an apartment and you suspect he's being financially exploited. You try as much as you can, but without having control over dad's bank and retirement accounts, you have a hard time stopping him from giving money to any scammer who calls. Dad has never done a power of attorney. One of his newest caregivers has recently cozied up to dad, and you're certain this person is taking his money as well. But dad likes this person, won't fire them, and all of a sudden you aren't allowed to come around the apartment. You've heard from the landlord that they just served an eviction notice on dad for failing to pay rent for the last 3 months. You can file a petition alleging that dad is incapacitated and ask the court to appoint you as his guardian and conservator. For the conservatorship over dad's money and property, you must get bonded. A surety bond is a special type of insurance policy that protects dad's assets from loss or misuse by the conservator. Once the petition is filed, the court will do 2 things. First, it will set a date for a hearing on the petition. Second, it will require notice of the hearing be given to several people. Notice must be given to the alleged incapacitated person, dad in our case, his spouse if he wasn't a widower, and all of Dad's adult children. The probate judge will then appoint 3 people who have different responsibilities in the proceeding: a physician, court representative, and guardian ad litem. Let's talk about their roles. The court-appointed physician will examine Dad and submit a report to the court. The court representative will talk to you, Dad, and others familiar with his situation. The court representative will also visit Dad's apartment and submit a report to the court. The guardian ad litem is a lawyer. Their job is to represent Dad's interest in the case, interview him, investigate facts, and represent what they think is in Dad's best interest. All of this information will be presented to the judge by the time for the hearing. At the hearing, the judge will hear the evidence, potentially take testimony, and decide if Dad is incapacitated and needs a guardian or conservator. You, as the petitioner, your lawyer, the court representative, the guardian ad litem, are typically all present at the hearing. Other people, including the examining physician, other medical experts, anyone contesting the guardianship, and others who have information about the incapacitated person, may also be present and testify at the hearing. Finally, and most importantly, Dad has a right to be at the hearing and speak for himself. If the judge grants the petition, you will receive what are called letters of guardianship and conservatorship. Read these carefully to make sure you understand what you are authorized to do. For example, Dad may be adamant that he wants to decide where he will live. Even if Dad is not at the hearing, his guardian ad litem could express this wish to the court. The judge may decide to limit your authority and allow Dad to make decisions about where he lives. You would then have the authority to make other decisions, including hiring and firing caregivers, arranging his medical care, and securing his finances. Pay close attention to the court's orders. Also, they will tell you what other things you will need to file with the court and when. Like any other legal proceedings, there are attorney's fees and court costs to pay. Court costs will vary from county to county, so make sure you ask what those costs are and when they'll be due. In the next 2 videos, we will go into more detail about the duties of guardians and conservators.
All right. Before we get started, I know we were going to leave some time for questions after each video, but I wanted to mention a couple of things about that video before we move on to the question portion. The first thing I wanted to mention is something that I briefly referenced, and that's being that the court would require certain things to be filed. This is something to me that is extremely important, and a lot of times you're going through the process and you're so concerned as filing that petition about making sure that the incapacitated person is protected and that their assets are protected and gathered, that you often lose sight of what happens after that initial hurdle. And inventories are a part of what have to be filed. You have to file an inventory, and then also accountings. And those accountings are either annual. We do those sometimes triennial. They have to be no more than every 3 years is what the law requires. And I think that's one thing that I see that some of our conservators get into some trouble, because you come in and you're the relationship to the person who is the incapacitated person. You're their son or daughter or niece or nephew or even spouse, and you have that familial relationship. But then when you come in and ask the court to be a conservator, that changes that relationship. You then have a fiduciary duty, and you have to account to the court for the monies that come in and go out and for the decisions that are made on behalf of that person. So I can't stress enough how important following up and making sure that you're filing all the paperwork and keeping up with things in an appropriate manner. And it's always good. I will say, I don't want to scare people off of applying to be or filing to be a guardian or conservator because of that relationship, because it's wonderful in that person appointed is so close to the incapacitated person that they know their wishes and expectations, even though that person may not be able at that time to communicate them. But I just caution, because it can be very hard because of that different relationship that creates. The other thing that I'll point out is it was noted in the video that everyone who can attend and does have a right to attend the hearing. I'm going to say that is our one positive that has come out of COVID for us, is that we have made use of Zoom like we are doing for this proceeding today and this conference today. We've been able to make use of that as well to allow people who are incapacitated, or at least alleged at that time to be incapacitated, to attend hearings where they might have otherwise, their presence might have been waived by their guardian ad litem because they were in a facility or somewhere that they could not, were not able to travel, but they are able to attend by Zoom and hear everything that's going on and participate in the hearing and be much more comfortable than if they were coming into the courtroom. Now, that doesn't work in every case, but that is definitely something I would say to ask. Not all courts are doing that. And there are certain times that it's appropriate and certain times that it is not, but that is definitely something to ask if the incapacitated person is in a facility that might make travel either impossible or difficult to participate in the proceeding. So with that, any questions?
Anyone, if you have a question, again, you can you can do it in the chat, put your question in the chat, or you can raise your hand or just come off mic too, if you'd like to do that.
Right, I'm not seeing any questions, but I don't want to cut that off, so we can certainly take those at the end if something else comes up. But I will go ahead and just start talking a little bit about the next video, which is video 10. The next video covers the topic of modifying or concluding a guardianship or conservatorship. To be completely candid, I'm going to say that we very rarely see petitions to modify guardianships or conservatorships, as the majority of what we do in the court system tend to be for people whose conditions are not likely to improve, but rather are more likely to deteriorate over time. I will say that on the rare occasion that we have seen a petition to modify or dismiss due to improvement in condition, there have been some amazing stories and some people who have come in who were formerly judged to be incapacitated that have made amazing recoveries, and to see how grateful they have been for the people in their lives who have stepped in and helped them and assist them in ways that they couldn't help themselves at that time. But then see them restored to full capacity and be able to do those things has been absolutely amazing. I'll also mention though that anytime that you have a conservatorship, and this will be covered in the video, but when the person dies or passes away, then those conservatorships don't just automatically end. There are documents and things that need to be filed to wind that up and make sure that things are taken care of appropriately and either passed on to a personal representative of an estate or otherwise disposing of assets as appropriate under the law. Well, Nate, I think we may have had a question come up before we go to the video. And Anne, you may have to help me with that. Let's see.
We did. The question is, are the fees or all of the fees paid from the ward's estate?
Typically, yes. Typically, the statute is going to set out how the fees are to be paid. However, I will note that if a petition is filed and then a guardianship or conservatorship is not granted, then fees may be assessed in other ways at that time. I hope that answers the question. All right. And with that, we'll move next to video number 10. And this video is modifying or concluding a guardianship or conservatorship.
In this final video in our series, we will discuss the ways guardianships and conservatorships can be modified and when they end. We will cover 4 scenarios. The first scenario is this: the incapacitated person regains capacity. This could be through the recovery from injuries, improvement in medical conditions or mental health, gaining of functional skills, use of effective medications, or advances in technology. The guardian or conservator can go back to the court and file a petition to have the guardianship or conservatorship terminated or limited. The incapacitated person can file a petition as well in their own right and regain their decision-making rights. This is sometimes called a restoration of rights proceeding. Here's an example from one court case. An 86-year-old woman had a stroke. Her niece was appointed conservator to manage her financial affairs. The aunt moved into an assisted living facility where her condition improved significantly. She wanted to go home and manage her own affairs and petition the court for termination. After reviewing clinical records showing improvement and hearing testimony from the aunt, the court granted the petition. The second scenario is this: the incapacitated person has developed sufficient decision-making supports and no longer needs the assistance of a guardian. Here's an example from another court case. The court appointed a mother as guardian of her 29-year-old daughter with intellectual disabilities. 3 years later, the daughter had developed a network of assistants, including a supportive husband, as well as help from her mother, close neighbors, other family members, and a social worker who secured necessary supportive services. The judge found the guardianship was no longer needed because there was a system of supported decision-making in place. The third scenario is this: something happens to the guardian or conservator. Someone may allege the guardian or conservator is shirking their responsibilities, misusing the incapacitated person's money, or at worst, hurting the person. They could petition the court to have the guardian or conservator removed. Perhaps the guardian or conservator has died or has become incapacitated due to their own declining health. Someone else can petition to become guardian or conservator. In each of these cases, the judge can appoint a new, or what's called a successor, guardian or conservator. The fourth scenario is this: the incapacitated person dies. The duties of a guardian or conservator technically cease when the incapacitated person dies. In reality, the guardian or conservator may be called upon to assist with final arrangements and pay funeral expenses and final bills. You should notify the court of the person's death and hold their possessions, money, and other properties safely. If you are serving as guardian only, the judge can terminate the guardianship. If you are serving as conservator, there are additional steps involved. You will eventually turn the person's money and property over to the executor of the person's will, a personal representative appointed by the judge, or perhaps a trustee named in a trust. As conservator, you will also be required to submit a final accounting to the court before it can terminate your conservatorship. If you are unsure what to do and when, you should consult with your attorney. Thank you for joining us in this series. Please share these videos and resources on our website with your friends, family, and colleagues, and anyone else who may be interested. Take care.
All right, so now we've watched the video about modifying or concluding. Does that bring up any questions? We'll note while I'm giving everybody a chance to respond, I'll note that one thing that I have had questions about here recently that I've been seeing it a lot are especially developmental disability cases, and then some where you have family members in other cases where they are asking about having co-guardians or co-conservators that are appointed. I will say, to me, co-guardians are a little bit different than co-conservators. With co-conservators, you have two people that are trying to manage money, and that's often very difficult unless they delineate their roles appropriately. Somebody may be writing the check and somebody's balancing the checkbook, or making some decisions and somebody's actually handling all of the money. It's hard, or at least in my experience, it has been hard for two people to get bonded to act in that role. So co-conservators, I think, are a little bit more tricky, if you would. Co-guardians also something that I'm seeing a little bit more frequently, that people are asking to be appointed guardians. And the decision there that we are coming down to that we have to discuss, and I have to ask a lot of questions, and the guardian ad litem's and attorneys involved are asking a lot of questions to make sure that the incapacitated person is appropriately protected, is how are they going to make decisions? Does it need to be a co-guardianship truly in the sense that they both have to agree, or can either of them make a decision independently? So is it an and co-guardianship or an or co-guardianship is the question that we then start dealing with. And that's going to be on a case-by-case basis, whether or not that is appropriate. Let's see, I'm seeing a question about explain the reporting requirements of guardians and conservators to include how often to visit with the ward. That is a great question and something that I'm seeing more frequently. There was a change in the law several years ago that it added basically a visitation statute that, or statutes that talks about how guardians are to govern and what their role is in limiting or allowing visitation. Those are very specific as far as the steps that the court has to go through. There are family members that are by a certain degree of kinship that can file a petition for visitation with the person who is the incapacitated person involved in the guardianship. The court then would evaluate whether or not that person has the capacity and ability to knowingly and voluntarily make a decision about whether visitation they want to visit with that person. If the person can make a decision about that and the court believes that they have capacity to make that decision, then the court is going to order that the guardian allow that person visitation. However, and where I have been seeing more cases is where the incapacitated person does not have the ability to make a decision about whether visitation with that person is in their best interest. Maybe they have been harming that person physically or financially or emotional abuse, things of that nature, that the incapacitated person is unaware of or unable to fully appreciate given their incapacity. If that is the case, then the court would make the decision that the guardian would be able to limit visitation as appropriate with that person. Does that answer the question that was asked? And do we have any other questions? And I will note, we're seeing those a lot more often, and I think that's just probably with that code section coming into play. I will, in talking with other probate judges, I know many of us are very leery of going down the path of basically becoming a domestic court, in the sense that we're setting out visitation schedules like you might see in a divorce case. I always say I'm trying not to micromanage my guardians, that you're appointing a guardian because they are going to make decisions that are in the best interest of the ward. And if they cannot do that, that's a problem in them being a guardian. So that visitation schedule, I think, is where some of us are having some issues in the bench, that we don't want to get into that scenario.
Judge, I had a issue, I guess, that we'd appreciate if you could address. I know I spent all of my career, one way or the other, working for the state. And sometimes when state agencies are providing services, and I know we've had some social workers on here for the series earlier, there are probably some on now. People that are relatives or friends of a person who may lack capacity may want a state agency to do certain things that they really are not empowered to do. And so I know in the video it talked about having the process and getting a person appointed as a guardian. But I guess the point I wanted to raise is people should seek if we haven't had surrogate decision-making tools in place and the last resort is needed, that people need to seek a family member or get independent legal advice because the agencies can't represent the person in that sense. Have you seen that or had any problems with that?
I have, and we do have problems with that. I will say the area that I see that a lot in here recently, and I think that's just an aging population too, but I've seen it a lot with folks who are involved in the commitment process. And they have always been dealing with involuntary commitment. They've maybe been clients or ordered through outpatient commitment to receive treatment through our local mental health center, and the family has been involved. But what I'm starting to see is that used to be their primary diagnosis and struggle, but now they are moving into, because of their age and other medical conditions, moving into dementia or Alzheimer's, and that is becoming more of the struggle. And so a lot of the families have been so used to using other agencies or the local mental health center that has somewhat been the liaison for them and helping get the person treatment, and it's been under court order. And then now it's almost time for the family to step back in at this point for a guardianship or conservatorship if that's appropriate. And that's where I'm seeing a lot of, I don't want to say pushback, but just where I feel like people are kind of falling through the cracks there because there isn't somebody willing to come in and do what's necessary. And there was no estate plan in place, basically strained relationships and other things that have gotten us to this point. If that makes sense.
Yes. And I know we've even had occasions, I see that James Tucker is on with us from ADAP, and he was our speaker last week. But there have been occasions where when we knew that a person needed a guardian and they may not be in a good position to hire one, or other family members or friends hire somebody for them, that we've asked ADAP to come in, and they have provided relief. And I know some local bars may have other programs. So do you, and hey, James, I see you on now. Either one of you have any comments about how people can seek the help in getting that guardian in place when they haven't otherwise gotten other measures in place to make decisions?
I think you just mentioned, as far as the state bar reaching out, local bars in the area that you are in, volunteer lawyer programs, things of that nature. I do have some that are filed as pro se petitions. And of course, we can't give legal advice in the court, but we certainly can get that court representative appointed and a guardian ad litem appointed, and get things at least moving in the right direction once that petition is filed. But sometimes that does slow down the process, obviously, if you have somebody who doesn't know exactly what they're doing when they're filing it. But the resources that you've just mentioned would be the ones that I would recommend.
Okay. Thank you. I see James's hand is up. James?
Thanks, Courtney. Thanks, Your Honor. I actually have a question, Your Honor. There was one comment in the video that I thought was intriguing, and it won't surprise either you or Courtney, but at ADAP, probably half or more of our guardian conservator practice is seeking modifications, and not necessarily a termination, but sometimes a limited guardianship, a change in guardianship, a change in powers, but seeking some kind of a modification. So I was intrigued, Courtney, by the comment in the video. And, in any law practice, you get the issues that come in the door. So, Your Honor, you can imagine the issues that get filtered to ADAP. But I was curious, Your Honor, about your perspective on if it is the case that seeking a modification is somewhat unusual. And I would also just share, Your Honor, that we've been in courts, not yours, but in other courts in Alabama, that when a probate judge told the ADAP lawyer that there was no such thing as a limited guardianship. So I was just wondering if you could comment a little bit more on this notion of alternatives, including even modification to even like a limited guardianship where there is still a guardian power. It's just specified more particularly. I was really curious about your perspective about that area of this practice, because it is a means of pursuing a less restrictive control, but still having some control if that's what the court might prefer.
Correct. And I will just say, obviously through Wings involvement and all of those things, guardianships and a limited guardianship are things that I personally think are wonderful and very useful. But I will just say the majority of petitions that we have come in and the majority of lawyers that come in and file guardianship and conservatorships, it is what they are asking for is basically they want everything under the code section. And I've been a little shocked at that. And I will say that sometimes I'm working with our guardian ad litem sometimes to raise questions about, is that really necessary? Especially when I have somebody who comes in and they're sitting in front of me or they're on Zoom and they're saying, yep, this is exactly what I want to have happen. And this is who I want to do this. And, you know, they're able to make those decisions, at least seemingly, about having people in place and assisting them. And so it's almost like we're not quite to the step of even needing a guardianship sometimes, which is a little concerning because you are giving away all of these powers and abilities. So I would just say, yes, I would welcome the modifications if that is something. And I obviously can't comment on cases that are in front of me, but I will say I have seen where that original guardianship and conservatorship were granted. And as we go through, and it's usually in an annual accounting or a triennial accounting, and we start talking about what's been going on, I have had the occasion to be able to step back a little bit and be able to limit what was originally ordered, to give that person a little bit more independence because they're already doing those things. So make sure that legally that they have the right and ability to do those things legally and that those rights haven't been taken away. I think some of that's just a learning process and education so that people know that those do exist, and filing a guardianship and conservatorship it's not just a cookie cutter, one size for everybody. This is, you know, something that you're granted that title and you can do everything or you can't do everything. Anything else? Yes, ma'am.
Judge Boyd, if your guardian or conservator both leave the area, say they've gotten another job or they've moved to another state, do you need to appoint a new guardian conservator, or what can be done in that case?
It kind of depends on if it's guardian and conservator and what they're able to do and what they're not able to do, not being in the state. I would say that's one of those, each situation is going to be very different. I will say, however, if you are going to move and you and the incapacitated person are going to move and leave the state, it's a really good idea to let the court know that. We've had a couple here recently where we've been tracking down. I've had an annual accounting or a triennial accounting that was supposed to be filed, and we send out those notices saying, hey, it's late, needs to come in, and I don't get a response. And then we start tracking people down and realize that no, we've moved and we've gone to whatever other state. And so we just thought that kind of went away when we moved to another state, and they may or may not have even gone through the guardianship and conservatorship processes in that other state, depending on their change of circumstances. So that is something that definitely you need to be notifying the court if anyone is moving, so that we can address that appropriately and take care of that situation and see if it's still going to work, that they would be able to serve in that capacity.
So if they do move to another state, both of them, then would the responsibility then fall under that state's courts?
We typically will have, then they will file a motion to transfer, and that is it's a different process depending on which state you are transferring to and what that state is asking you to jump through those hoops. We have transferred both to and from other states. I will occasionally have requests to open a new guardianship or conservatorship here when the person is moving from out of state. And we have a code section that we follow, and the same thing applies to the other states. Does that answer your question?
Yes, thank you.
Without getting into the weeds too much on specifics with each state.
Judge, and I don't want to get too legalistic here, but can you speak to instances of any concurrent jurisdiction with circuit courts on matters that might involve guardianships? I just recently had a call from an attorney who was hadn't done a lot of guardianships, and my perspective is this circuit court was dealing with someone who might have been in need of protection through the circuit court process. So a guardian was in place, but I know that may be confusing to folks as to what court you're going to for what purpose to get a guardianship.
Sure. Right now, the Adult Protective Services cases original jurisdiction is in the circuit court, and I think that's where some of the confusion is. I will tell you that some counties, just in speaking informally with some of the other probate judges, some counties actually are working with their circuit courts, and they are, once that is established and a guardian or conservator is appointed in those cases, they are actually, and I hate to say transfer because that may not be the right mechanism that they are using, but they are basically moving supervision back to the probate court because they feel that it's more equipped to be able to monitor those activities of the guardian and conservator. I will just say in our county, that is not something we have been doing. Our circuit court maintains those cases when they have them. And I will also say some of our circuit court cases, they are acting more on an emergency basis. And then when they realize that something permanent needs to be in place, then they will send them to us in the probate court. So they take care of the emergency situation, and then they would send someone to file a permanent petition, or as permanent as a petition would be, to the probate court to establish what I would consider to be more of a traditional guardianship and conservatorship.
That sounds like it may be a better practice.
But does anybody else have any more questions? If you do, you can just unmute yourself. There's one more. Is a guardian and conservator most often the same person?
Well, that's a good question. That's a loaded question, though. Yeah, it can be, and most of the time it is. However, there are certain reasons, and I will say a lot of contested guardianships and conservatorships that I have seen. That's often where we make the split, that there is somebody who would be a wonderful person to make some decisions as far as a guardian and serve in that role. But as conservator, they just may not be the most appropriate person to be able to handle the finances and make financial decisions. And so sometimes we would bring maybe, I've had attorneys that have been appointed as conservator and a family member who's been appointed as guardian. If that family member was unable to meet and comply with the statutes and things and the requirements of the conservator. So typically that's what I see, is that they run together unless there is some kind of a conflict. I will say sometimes you'll see families that have it worked out and they petition that one family member is going to be a guardian and the other is going to be conservator, simply because one of them, in that location question that Ann asked earlier, as far as one of them maybe here and live in the home with the person who is incapacitated, and so they are better suited to be the guardian, but the other person is better with the finances and more able to manage that, and so they are more suited to be the conservator. And so I have seen that and actually seen that work very well.
All right. Well, I don't see any hands up or any other questions. Ann? Any other comments you have?
I do not. I think we're pretty good. Thank you so much, Judge Boyd, and for this presentation and for all of the insight that goes along with it, because I know that there are so many questions that people have about guardianship and conservatorship. Mr. Tucker has a question. He has his hand up.
Clapping for the judge and Courtney. Thanks, Ann. No
Thank
more
you.
questions.
Great. Yes, I thought it was wonderful. Thank you so much.
Thank you.
Everyone, we have next week, or Courtney, I'll let you close it out and you can talk about what we're doing next week.
All right. Well, thank you. Thank you so much, Judge Boyd. We really appreciate the information you've given us today, and know it will be helpful to many. And we'd like to thank all of you for joining this session. Please join us next Tuesday when we'll look at the responsibilities of guardians and conservators. And our guest will be Attorney Connie Glass. Thank you so much.
Thank you all. Happy Thanksgiving.
Thank
Happy
you,
Thanksgiving.
everyone.
Happy Thanksgiving.
Happy Thanksgiving.